Now this is a 366-page tome that we have in front of us that's come after around 2,500 pages of written submissions, a record that runs into 42,000 pages. And if I'm being honest, this judgment is not worth the paper that it's written on. Let's start looking at each of these opinions, and I think it's quite something to start with Justice Bhatt's opinion. He starts his opinion saying that the prayer of the petitioners is to seek recognition of queer marriages. And on the next page, he confuses it with solemnization and registration. Now understand this. Registration, recognition, and solemnization are three different legal processes. Recognition happens by the state, registration happens by the state, and solemnization happens either by religion, if it is under a religious personal law, or it happens by the state if it is in case of a special marriage act. And the reason behind that is that once you are within the ambit of the special marriage act, your religion, your culture gets thrown out. It does come into the back door in some cases of inheritance, etc., in cases where Section 21A, etc. is considered. But that was not the subject matter of the challenge. However, what we see throughout the course of this judgment is a repeated reference to culture, a repeated reference to history, a repeated reference to what the Hindu marriage looked like. This judgment, to my opinion, is far more sinister than it being a cause for marriage equality. What does this repeated this repeated reference to culture, a repeated reference to the olden times, pre-constitutional times tell us? It tells us that while the Constitution of India is still in place, the judges today have told us that the culture precedes the Constitution as a source of law. And that, to my mind, is a grave threat to democracy broadly. Look, let's not skedaddle around it and address the issue. Political ideology of judges is coming to the center stage with the more polarization that we see in the bar, across lawyers, across parties, and across this. And it's day into day, what we are finding is that judges tend to be more and more pro-state, right? Earlier it used to be one or two or three judges. Now, if I'm being candid, in the Supreme Court, a majority of judges tend to be pro-state. And that is not to say that, the court is compromised with. We're still not there yet. But if this trend continues, if this trend of relying on religion, if this trend of relying on culture, while ignoring the Constitution, continues, then we might come to a day when the religion will be a norm that is higher than our Constitution, and I think that is very dangerous for us as a democracy. Now let's come to the judgment and the specifics of the judgment. Now, if you've come here, most of you will know that there are around 23, 24 petitions across 50 petitioners broadly in the Supreme Court. The Supreme Court in March transferred all the cases from the High Court to itself. What were our arguments, right? And I think I speak for all of us who were representing the petitioners. Our arguments were, look, your Special Marriage Act exists in a structure which is atheist, right? It's a secular structure. And the second argument was that the notice regime should go. The initial set of petitions were under the Hindu Marriage Act and the Special Marriage Act more broadly, except Shivangi's client, where they challenged the constitutional validity of all religious personal laws. The first day we walk in, the court tells us that we're not looking into examining the personal laws at this stage. Fine, no grievance with that. Now what remains for challenge and for interpretation in the Supreme Court is only the Special Marriage Act. Let's look at what the Special Marriage Act was. Why was it enacted? It was enacted to allow marriages between interfaith couples, right, in the 1950s. These were couples that did not have sanction of society, and the state felt that it was in legitimate state interest to intervene and pass a law that allows interfaith couples to marry. One of the arguments that we made before the judges was that look at the purpose of the Special Marriage Act. It was not just interfaith couples, but should be construed as more broadly as couples who do not have social sanction to marry, and therefore cannot marry within the ambit of their religious laws. The Special Marriage Act in that way is an atheistic statute. Save for this one instance where two Hindus marry each other, then you walk in by a backdoor amendment that happens subsequently, and the Hindu laws of inheritance govern. Otherwise, you fall within the ambit of the Indian Succession Act. Now, the judges chose to reject that argument and perhaps have even misconstrued our argument. Justice Narasimha, in his opinion, for example, says, look, this is virtually a mandamus to create space in policy and legislative spaces. No, it's not, with respect. What we said is that Section 4 of the Special Marriage Act only talks about marriage between any two persons, and same was the case with the Hindu Marriage Act, marriage between any two Hindus. But the court did not find merit in our argument. Instead, what the court has chosen to do, in what is extreme legal whataboutery, is ignore the queer persons the right to marry a person of their choice. Or as Rituparna's petition said, form families of choice. It's quite worrying what's happened. But I think the judgment apart, it also calls for a broader conversation within the queer rights movement. I think I speak for a lot of us who feel that conversations are kind of died down. Right? People aren't speaking to each other as much as they should. Perhaps us lawyers are also a part of the problem in that we've come to realize that the only way of winning issues is by litigating them. We've kind of forgotten the brilliant work done by folks like Rituparna and folks at Nazariya, the grassroots organizations around the country. But we've come to a point where the court has thwarted the movement, so to speak. And it is a big blow. Let's not make let's not make two ways about it. What next? We've had a few days to deal from the judgment. We will, of course, be filing review petitions sooner rather than later, asking the court to reconsider its verdict. Another very worrying instance is that they've taken away the right to marry a person of your choice from the level of a fundamental right to a statutory right. Now, for those of you that are not lawyers, what does it mean? If there is a fundamental right to marry a person of your choice, it means that if the state wants to interfere with your liberty to marry that person, that it has to enact a valid law. But now the court has degraded it to a status of a statutory right, which means that the parliament giveth and the parliament taketh away. Tomorrow the parliament chooses to repeal the Special Marriage Act, we'll be left with no other option but to live with it. Instead, what the court interestingly does is carve out what it calls a right of choice to cohabit with a person of your choice. So, again, there's no duty cast upon the state to recognize such a union. And so that, again, is a very worrying issue. And I think I'll keep it short at that, and I'll let Shivangi speak for a bit.
I completely agree with the observations Rohin has about the verdict, that the reliance on customs and religion is so much when all the petitions were challenged the constitutionality of Special Marriage Act, which is, again, as you mentioned, is a secular enactment. Also, while drawing, the institution of marriage through customs, etc., the court completely, they were blind to the fact that these unions already exist. We don't have to trace them back to any customs, etc., even though they can be traced back. However, that was not the petition, that was not the argument that was made in the courts anyway. Right? These unions they already exist. The petitioner who had come before the court either had married in other countries or were living in a union, as Justice Bhatt in his judgment says that, the fact that they are not recognizing these marriages does not preclude them from entering into the celebrations of this. But the queer couples have been doing that for many years now, and that's why we went to the court saying that, see, we are in a union, it lacks state's recognition. The state has failed to do it, so there is a positive obligation on this constitutional court, under the very power that they have, which they chose not to exercise through this verdict. And everybody remembers 17th October, 10:45, 10:50, when they started pronouncing the judgment. And we all, it's still fresh in our hearts and mind the way the verdict was being pronounced. Chief Justice started by saying there are some agreements, there are some disagreements. And juristically speaking, we were all ready that, it's not going to be a, unanimous judgment. We were ready that there will be some disagreements. However, none of us were ready for this to be 3:2 on the other side. We were not, and the way it was pronounced, Chief Justice started with his judgment, and then Justice Call started, which gave us the recognition of civil union. Although they made it very clear it is not, akin to the institution of marriage. And then Justice Bhatt pronounced his judgment, which we gathered is, it's not in our favor. And then Justice Kohli and Justice Nasimha concurred with Justice Bhatt. And very weird and funny part is, this is a verdict where everyone on the bench agrees, yes, there is discrimination. There is discrimination, however, they chose not to do anything. They chose not to exercise their power under Article 32 to curb the discrimination. Justice Bhatt, even in the hollow directions that were passed by Chief Justice in his judgment, to protect the rights of queer couple, to give directions to police and everything, although those directions already exist in previous judgments and Transgender Protection Act and rules, etc. Those directions were not even signed by the majority judges on the bench, which is very surprising to me. Another surprising thing that I found was, Justice Bhatt says that if they recognize the union between queer couples, they will give rise to a new institution, which is absolutely incorrect. They will not be giving rise to any new institutions because these unions exist on their own. What they're sadly lacking is a state recognition, which they were supposed to give. Now, as per Justice Bhatt, they are not giving a recognition because they say that is they're overstepping the bounds of the judiciary, and it is only up to the parliament to make a statute on this. As he said, there is no fundamental right to marry, although that was not argued per se that, we're asking for a fundamental right to marry. We said there is right to marry for everyone because it is part of our right to life. So again, that argument was misconstrued. And every time I, read the verdict, all I understand is all the arguments made by the petitioner are just misconstrued in this judgment. They were not even considered. Even Justice Bhatt writes in his postscript that the absence of law or regulatory framework, as we went to the court, because there is no law in place under which a queer couple can get married. So Justice Bhatt's argument is that the absence of law, regulatory framework, or the failure of state to enact such a law, that amounts to discrimination. However, that was perhaps neither argued nor answered by us, which is absolutely incorrect. We, in our petition, in our written submission, clearly had explained to the courts that there is a lack of statute under which the queer couples can get married. There is absence of law, and state has chose not to act on it. That's why we had gone to the Supreme Court, and Supreme Court, in their power, they have large enough powers to to pass direction, to make guidelines to that effect. There is a positive obligation on the Supreme Court when they realize, when they very explicitly say yes, there is discrimination, and there is discrimination because the marriage of queer couples the union of queer couples are not recognized by state, even after being on agreement on that part. The court has chose not to exercise their power. Moreover, another thing that this verdict has is a setback to all is on the adoption. Earlier, a lot of queer couples were adopting children as single parent. However, sadly, in 2002, CARA came out with a circular that prohibited couples in a live-in to adopt children, which was rightly pointed out to the bench when Justice Chandrachud had pointed out that queer couples can adopt children as single parent. However, that circular of NALSA was brought to his knowledge that not anymore after this particular circular, and now a constitution bench of 5 judges have decided that that particular circular is valid and passes the constitutional challenge, which is a huge setback for queer couples who are adopting children, because if they are in a live-in, they won't be able to adopt children anymore, and it will be very difficult to challenge the circular, because now it has backing of a constitutional bench, which sadly is a step back from all the fight that people have put forward. So I believe this verdict is unfortunate. Our Supreme Court had an opportunity to not just exercise their powers under the Constitution, but also come to the aid of the queer community of this country. None of their observations about the discrimination that is faced by the queer couples have any effect in real life until and unless there are directions which are applicable on state, which puts state in a position that they have to follow through. Sadly, none of that has happened, and this is an unfortunate verdict.